No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
Big docket, big decisions, and Mr. Smith's freedom hanging in the balance. Over 400 days locked up, a $200,000 arson bond, and a possible probation deal looming. But the judge isn't rushing. Will structure win him release? Subscribe for more dramatic breakdowns as this courtroom chess match unfolds.
I'd ask the court to, Mr. Childers and I have worked on this file. I'd ask the court to adjourn this matter till next Thursday in hopes that we can get a solid resolution in this matter that works for both Mr. Smith.
He's being sent to another matter on Tuesday.
Yes, he's seeing Judge Kunke Tuesday.
Got it. Okay. Probable cause conference will be adjourned to March 5th, 2026.
Your Honor, if I could be heard on bond.
You can.
Currently, Mr. Smith has a sizable bond on one of these matters. On the arson matter, it's I believe it's in excess of $200,000. I think there might be a 10% privilege. He's also got a nominal bond on the possession charge. He's got a remand with Judge Kunke in the circuit court matter. Where I believe they're hoping for either a time served or a probation resolution there. He's been in a considerable amount of time on this stretch. I think it's 400 days plus maybe 406 if I recall from looking at it this morning. I did speak to his mother who reports he can stay with her in Canton. The people who reside at that location are his mom and his brother Tyrone, and neither one of them are on probation or parole for anything right now. I believe a tether would be in order. If he can't stay there, he reports that he may be able to go to the Delana Center, and he may still have access to his job at McDonald's should he be released. He does have some funds to support his. He believes he has some funds to kind of support his living expenses. Food, deodorant, things like toiletries, things like that. If he is released, and I believe that. He may get some type of Social Security disability, which would be reinstated. It kind of gets paused while you're incarcerated. Right. So we'd ask the court to consider releasing him or reducing the bond in this matter while we try and work out a resolution between now and next Thursday.
I don't need a response to the people. It seems to me that if he's being held on that case in circuit, I'm not going to change anything. I'm not saying, so Mr. Smith, I'm not saying no. I'm just saying I'm going to wait to see what they do there. I'll see you 2 days afterwards, and then I'll make a decision on it. But what I would like to see for Mr. Smith is before the court's going to really consider any release, I need what you've indicated, Mr. Guiding, more structured for the court, so that we have those things around him so it doesn't end up back here. All right.
Yes, thank you. Oh, and one thing I should say, he is on an ATO with CMH, so that would probably continue if you
with him. Okay. All right. Because so I'll look at it next week. Okay, Mr. Smith. All right.
Thank you.
I'll do that, and I'll just say, Mr. Smith, I've seen you a number of times, and you're looking a whole lot better than you have in the past. So something's working. Okay, we'll see you next week. Court calls the case, People versus Devon Brown.
Your agreement took for the people.
Well, Judge Torshell Feaster, Assistant Public Defender on behalf of Mr. Brown, who should be on Zoom.
Is he? Oh, okay, there he is. State your name, sir.
Devon Brown.
What are we doing?
Thank you, Judge. I have spoken to the people in this matter. I think we're prepared to set this matter for preliminary examination. I believe all discovery is complete to my knowledge.
People have their witnesses available the 10th.
Do our best, Your Honor.
Preliminary examination in person will be set March 10th, 2026, 9 a.m. before Judge Garwood.
Thank you.
Thank you, Judge.
Bond continued. Thank you. Court does call the case People versus Thurman Pool.
for the people.
These. Sir? Is he? Are all of these part of this block up here? Why are these files here?
I just have to do more before you get this is this block, but that's it.
Oh, waiting, your name, sir?
Pool, Thurman Pool.
Johnson. I know, but now we lost Feaster.
To see if he was in the restroom. Oh, here.
Oh, okay. I knew he'd show up. I don't know. You guys are saying all those bad things about him. Miss Johnson.
Better be talked about and forgotten.
That is true. All right, go ahead, sir. I've called the case.
Good morning, man. Please, Honorable Court. Kareem Johnson on behalf of Thurman Pool stands to my immediate right.
Thurman
Pool,
Good morning, Your Honor.
All right, good morning. All right, what are we doing?
Now, we ask this matter be set for exam. This is a co-defendant case, and I'd like to address bond.
The co-defendant case, who?
That was one that was earlier was adjourned one for PCC.
Okay.
So I have no objection to for exam. I'll hopefully get 3 weeks out, so that way in case that other case gets set for exam.
Yeah, and I hate to set a examination date with another attorney, not confirming that date's gonna.
Yeah, which case was that?
Marcus Claiborne was the co-defendant.
Next week.
Who's his attorney?
Jess.
Okay, but we're gonna try to hold them together, and I don't know what Mr. Burgess' schedule. He wants an exam. They're gonna be held together. So let me pass this matter briefly. Somebody get Mr. Burgess on the phone and see if I set a date on this one, whether or not he would join in that next week when he comes back, because I think he was just appointed on Claiborne, right? Just today.
I could be back the 5th, and we can do it that way, yeah.
You want to do, okay,
Yep.
all right, thank you, Mr. Johnson, that'll work. Probable cause conference will be adjourned March 5th, 2026, 9 a.m. Bonds will continue. All right. Yes, go ahead.
I'll address it next week, yeah.
Okay.
All right, thank
All
you.
right, very good. Thank you. Court calls case People versus Tyler Cardena. I said that all wrong.
Mayor Michael Gaddy, Assistant Public Defender on behalf of Mr. Cardenio, who's approaching. Cartagena,
I
sir.
understand. All right, thank you.
What's your name?
What are we doing?
Cartagena.
Your Honor, at this time, we're asking the court to set an exam.
Preliminary examination. All right, discovery is complete.
Yes, Judge.
People have their witnesses available to 10. Preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Washington. Bond will continue.
Thank you, Judge.
Thank you. Court calls case People versus Elenia Thomas.
Alex Jablonski for the people.
Assistant Public Defender Nick Bukovich from Ms. Thomas, who is now approaching. Thomas, can you please state your name for the record?
Thank you. What are we doing?
At this time, Your Honor, will be requesting to set this matter for preliminary. All discovery to my knowledge is complete, and I would like to address bond when appropriate.
Would people have their witnesses available to 10?
Yes.
Preliminary examination in person, March 10th, 2026, 9 a.m. before Judge Garwood. As to bond.
As to bond, Your Honor, at this time, I'd like to request a personal reconnaissance bond. I do believe my client's last court date was a failure to appear for a PCC, so a bench warrant was issued. She has indicated to my office that she believes she was in the hospital at this time, which caused her to miss that court date. She does have some
Do I
severe.
have proof of the hospitalization?
She believed that she had the information sent over to the court.
I don't have anything regarding that.
Understood, Your Honor.
If you get it over to me, I would consider it or have Judge Garwood could consider it, but at this time, motion for bond reduction denied, bond will continue. Thank you.
Understood, Your Honor.
Court calls case, People versus Deborah Collette.
This is critical. The judge isn't denying bond outright, but strategically waiting for the circuit court outcome. That's smart judicial caution. Without structure, supervision, and verified housing, release becomes risky. The court wants safeguards, not promises. Question is, can Smith deliver proof before next week, or is this opportunity slipping away?
Is that it for the day?
And
Good morning.
this is
Hello?
about defendant on behalf of Ms. Collette.
Okay, Ms. Collette, state your name. No, you're good.
Good morning, Your Honor. My name is Deborah Joanne Collette.
Thank you. All right, what are we doing?
At this time, Your Honor, I'll be requesting an adjournment to obtain some medical documentation to provide to the prosecution in hopes of reaching resolution.
Probable cause conference will be adjourned March 26, 2026, 9 a.m. Bond continued.
Thank you, Your Honor.
All right, thank you, Ms.
Thank you,
Collette.
Your Honor. Have a good day.
You too. Court does call the case, People versus Danina Combs, 2 cases.
Oh, thank you, Lord.
Or Shell Feaster, Assistant Public Defender on behalf of Danita Combs, who I believe is on Zoom.
You think?
Hi,
Take it. Oh, maybe. Hold on. Your name?
I'm Danina Combs.
All right, she's
All right.
there.
All right, great. Thank you, Judge. We are still in negotiations. I don't have resolved this yet. We'd ask for a brief adjournment.
Probable cause conference will be adjourned March 19th, 2026, 9 a.m.
Thank you, Judge.
Bond continued. Court calls the case of the People versus D'Amico Cummings. Excuse me.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Cummings. State your name, Mr. Cummings.
Good morning, Your Honor. D'Amico Cummings for the record.
Thank you.
Your Honor, we're asking for an exam in this matter.
Discovery is complete.
Yes, Judge.
People have their witnesses available the 10th. Preliminary examination in person will be set March 10th, 2026, 9 a.m. before Judge Washington.
Your Honor, if I could be heard on a bond condition.
Yes.
Your Honor, Mr. Cummings, as part of the bond conditions in this matter, was ordered not to go to MacArthur or not to go to Schooner, to the address at Schooner Cove. This is the location of the alleged incident, but according to the police report and according to Mr. Cummings, this isn't where the complaining witness lives. She lives in Canton. So he'd asked the court to, and she doesn't reside at that address, and to our understanding hasn't been there. We'd ask the court to amend the no-go to allow him to return home. He lives there, he and his mother.
Her address is a Canton address, so I have that Canton address, however, I don't have confirmation that she's not residing there for her, but her address.
All right. Without that confirmation, I'm reluctant to change anything.
Oh, I understand, Your Honor. So if we can get that confirmation, I'll submit an order for your review, if that's okay.
Pardon?
If we can get that confirmation, I'll submit an order for your review, if that's okay.
Okay. All right. Bond will continue. Thank you.
Thank you, Judge.
My mic is flashing. I did not touch anything. But picking me up,
All the other, I mean, you're getting picked up by this.
I'm getting picked up by that one, but this one's out.
Yeah.
No, it's not now.
Okay.
I fixed it. Court calls the case, People versus Vasquez Davis. They
Your
want,
Honor, Raymond Cook with people.
they want to check that on the break.
Mr. Public Defender, Chinazi Terry, I can rule Your Honor on behalf of that's what Davis.
Hey, how you doing today, sir?
I'm doing great. How you doing?
I'm good, man.
All right.
Good that you better, you feeling better than me.
What's your name, Vasquez?
Vasquez Davis.
We are asking for an adjournment today.
What a shot.
Just,
No, go ahead.
is that litigation information that I need to forward to the people to review?
All right. So how much time is that going to get?
I think 2 weeks is fine, Judge. I already have it completed.
March 19th, 2026, 9 a.m.
Thank you.
All right, sir?
Yeah.
All right, have a nice day, sir.
All right, take care. Bye. See ya.
Yeah, just like that.
Bye. He's gone.
Yeah.
His stuff was over. Court calls the case, People versus Ryan DeLon. Donlon, maybe.
And Stephanie Cannon on behalf of Mr. Dunn.
How you doing, Your Honor? Good. All right, what are we doing?
Your Honor, we actually have come to a resolution on this. We're just asking so that we can get the plea on the record.
Get the forms and stuff in.
Yes.
Probable cause conference, March 12th, 2026, 9 a.m. Bond continued. All right, sir.
Thank you, Your Honor.
Thank you, sir. Court calls case, People versus Ashley Floyd.
And this is public defendant Nicholas Bukovich from Ms. Floyd. We should be appearing via Zoom.
Yep. Ma'am, can you state your name?
Yes, sir. Ashley Floyd.
All right. Before me, a plea form that indicates who wrote this.
That would be me, Your Honor.
Okay, all right. Hold on. I'll get it, Mr. Cook. We're account 3 of receipt and concealment, 200 to 1,000. Is that what that says?
Yes.
Okay. The 1-year offense. Upon its successful plea to that charge, counts 1 and 2 would be dismissed. That is the court's full understanding of the agreement.
That is correct.
Yes, Your Honor.
Penmanship aside.
Yes.
Reason's not my hearing this time.
Well, I don't know if you can even call that penmanship, but that's all right. Okay. You're right. All right. Miss Floyd,
Yes,
can you
sir.
raise your right
Yes, sir.
hand to be sworn? There you go. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
Yes, sir.
All right. State your name again for me.
Ashley Floyd.
All right, ma'am, it is this court's understanding that you're going to be pleading guilty to the charge of receipt and concealment of stolen property, $200 to $1,000. That's
Yes.
a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The court fine could be increased if 3 times the value of the property that's receipt and concealed. If that's greater than $2,000, that would become the maximum penalty, maximum fine. You understand that?
Yes, sir.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would
Yes,
be
sir.
sentenced before Judge Barr in the 14A2 District Court.
Yes, sir.
Still wish to plead guilty?
Yes, sir.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, sir.
You had caused a advice of rights to be signed on your behalf. Is that correct?
Yes, sir.
Did you have any question regarding any of those rights?
No, sir.
You understand that you're waiving or giving up those rights, including the trial rights contained in paragraph 5.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, no, sir.
Has anybody promised you anything other than what's been stated here today to get you to plead?
No, sir.
Has anybody threatened you or coerced you?
No, sir.
You're doing this voluntarily and of your own free will?
Yes, sir.
And also because you believe that you're guilty of this offense?
Yes, sir.
Well, let's go here. On the date of December 26, 2025, location of 424 South Mansfield Street in the city of Ypsilanti, Washtenaw County, state of Michigan. What did you do that makes you think that you're guilty of receipt and concealment?
I walked in a bank and tried to cash a check with someone else's ID.
And there it is, the admission. Walking into a bank with someone else's ID and check, that instantly locks in intent. The judge carefully builds the record, ensuring every element fits. No loopholes, no ambiguity. Once she says yes to knowing it wasn't hers, the plea becomes airtight. Game over.
Ms. Ford, did you know that check was not yours because it had someone else's name on it?
Yes, sir.
And would that be reason for you to know that that check was not yours? You're in possession of someone else's check.
Yes, sir.
And would that check have a?
So the property we're talking about is the check.
Yes.
And she had received that and she concealed the check. Okay, and what was the amount on the check?
I don't remember.
Was it over $200?
Yes, sir.
A little bit weird, but I guess. All right. And you didn't have the owner of that check, you didn't have their permission to have that property in your possession, is that correct?
No, sir.
All right. Ma'am, if I accept your plea, I do have to advise you that if between the time I accept your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people?
No, Your Honor.
And have I complied with the court?
Yes, Your Honor.
The defense is satisfied, Your Honor.
The court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. I think that's right. No, count 3. If the plea to count 3, counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1482. Probation sentencing will be March 11, 2026, 10 a.m. before Judge Barr. Bond will continue. All right?
Yes, sir.
Thank you, ma'am.
Thank you, Your Honor.
Court does call the case People versus Dallas Fritz.
And then I have the people.
The judge. Marshall Feaster, Assistant Public Defender, on behalf of Mr. Fritz, who should be on Zoom from treatment, Your Honor.
Dallas Fritz? No.
My understanding is that the court released him to treatment. My understanding is his grandfather is here. He's in inpatient treatment. So I don't know why he is not present on the Zoom today, Your Honor.
So he was from the jail, he got released?
That's my understanding, Judge, yes.
He's been on, I believe he was given a PR originally, but he himself went to treatment. He's been in treatment since the beginning of this case. So he's only appeared on Zoom from treatment.
Got it. But he's not on today.
I'd ask if the court will
So you
consider
want me to,
adjourning.
you want me to do a bench warrant?
I do not.
No, is that what you want?
I would prefer you
Because
not.
this year you haven't done, I'm worried about you, man.
I'm sorry, Judge. I'm trying to get it together. I'm sorry, Judge. But I would request at least a 1-week adjournment. I'll have his grandfather confirm and get him back on Zoom for next week, please.
Where's Grandpa? Right there. I believe him, not you. All right.
Yes, he said, honestly.
I'll adjourn it to March 12, 2026, 9 a.m. All right, sir. Thank you.
Thank you, Judge.
Call the case of the People versus Roderick Jacobs.
People?
Your Honor, Joy Gaines, Senior Assistant Public Defender, with and on behalf of Mr. Jacobs. Please state your name, sir.
Roger Jacobs.
I have before me a plea form that indicates that the defendant would be pleading no contest to the charge of disturbing the peace upon his, that's a count 3. Upon a successful plea to that charge, counts 1 and 2 would be dismissed. There is an agreement that the prosecutor will recommend no upfront jail. That's the court's full understanding.
That's correct, Your Honor.
That's correct, Your Honor.
Let's have him sworn.
Raise your right hand. Do you solemnly swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. So help you God. Yes. State your name, please.
Roger Jacobs.
Sir, it is this court's understanding that you are going to be pleading no contest to the charge of disturbing the peace. That is a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. You understand that?
Yes, sir.
You understand what a no contest plea is?
Yes, sir.
All right, 2 things about it. I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes, sir.
Second thing is that for purposes of sentencing, the court was going to treat you the same as though you had pled guilty. You understand that?
Yes, sir.
And you understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes, sir.
All right. Still wish to plead no contest?
Yes, sir.
Basis for the no contest plea?
Potential civil liability.
Sir, to that charge, how do you plead?
Guilty.
Really?
Oh, no contest. Contest.
Went through all that. Now, all right. You're pleading no contest?
Wait, you confusing me. I'm sorry.
All right, sir. So to that charge, how do you plead?
No contest.
All right. Now you understand that we're pleading no contest. You'll not have a trial of any kind.
Yes, sir.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding any of those rights?
No, sir.
All right, please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right.
Yes, sir.
Are you on probation or parole?
No, sir.
Anybody promise you anything other than what's been stated here today?
Sir.
Anybody threaten you or coerce you?
No, sir.
All right, you're doing this voluntarily and of your own free will?
Yes, sir.
Court has been handed and has reviewed Washington County Sheriff's Office report for their case 22-39268. Any objection to the court having reviewed that report?
None from the people.
No, thank you, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if between the time of my acceptance of your plea and the time of sentencing, you commit misconduct as defined under the Michigan court rules, you would not be entitled to withdraw your plea and the court would not be bound by any sentence evaluation or recommendation. You understand that?
Yes, sir.
Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
None from the people.
No, thank you, Your Honor.
And have I complied with the court rule?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's no contest plea to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing will be
April 2nd at 10 a.m.
April 2nd, 2026, 10 a.m. before Judge Washington. Bond will continue. Thank you. You can go now.
I'm sorry.
No, it's okay. It's okay. No, I don't know what. Go ahead, finish your conversation. I apparently have all day.
I just wanted,
It's not, no, it's his fault, not yours, Mr. James. Court calls the case, People versus Norwood Masters.
and on behalf of Mr. Masters, who is approaching.
Thank you. What are we doing?
We're requesting to adjourn this matter, Your Honor.
Cause conference will be adjourned March 19th, 2026, 9 a.m.
Yes, sir.
Bob, continue.
Thank you.
Thank you. Exactly. Is your client here?
Yes, Your Honor, I believe you have.
Court recalls the case, People versus Tyler Smith.
Morning again, Your Honor. Raymond Cook.
And good morning again, Your Honor. Robert Ellman with and on behalf of Ms. Smith, who I believe is over Zoom.
Here.
Thank you again, Your Honor, for passing this. Ms. Smith, can you please state your name?
Todd Smith.
Thank you. Your Honor, the people and I have reached a resolution in this matter. However, we need some additional time to get the paperwork to Your Honor, so I'd be asking for an adjournment.
March 12th, 2026, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you.
Thank
All right.
you.
Your day.
I will do. Thank you, Ms. Smith.
2 pleas, multiple dismissals, and structured sentencing dates set. The court methodically ensures rights are waived properly. No coercion, no confusion, especially clarifying that no contest means no trial. Consequences now shift to sentencing judges. Like, comment, and subscribe for more shocking courtroom stories and real legal drama breakdowns.